My name is Greg Peterson. I'm an attorney with Phillips Lytle here in the Buffalo area. My office is in Jamestown, New York. And Jamestown is important as that is the location of the Robert H. Jackson Center. And you are in the Robert H. Jackson United States Federal Courthouse. And Jackson was a United States Supreme Court justice who was involved in a case of which you will hear about today, West Virginia versus Barnett. It's a flag salute case that occurred in the 1940s. And a little bit of background. Robert Jackson, whose name adorns the courthouse, was born in 1892 just outside of in Warren County, Pennsylvania. Grew up in Frewsburg, New York, which is in Chautauqua County. Spent most of his adult life in Jamestown, New York. He is an answer to a Jeopardy question. Don't you answer, because you've already heard the question. Name the only person in the history of the United States, to be Solicitor General, Attorney General, and a Justice of the United States Supreme Court. Who was Robert H. Jackson? Robert H. Jackson, from Western New York, never went to college. Never graduated from law school, and became the answer to a final Jeopardy question. And as part of that, he was a justice of the Supreme Court, and during that time as a justice of the Supreme Court, he heard this flag salute case, which you'll hear about today. Colin Kaepernick, who Nike commercial, kneeling, NFL, you'll hear that today. That's a very important part of today's discussion and its rights. And in fact, the title of today's presentation is in fact Freedom of Expression. Just do it? Question mark. And you're going to hear that from Professor Helen Drew, who I will introduce a little bit earlier. But a little backdrop on the Barnett case. In the 1930s in Nazi Germany, the Jehovah's Witness was a religious organization. Anybody heard of Jehovah's Witness? And part of their tenets is the fact they do not worship graven images, which is very biblical. And part of that at the time was the Nazi swastika, the Nazi flag, and essentially Heil Hitler, worshiping Hitler. So they would not do that. So whenever there was German assemblies and that somebody from the party and everybody would go Heil Hitler, they would not. They would just stand there. And they were then in turn rounded up and sent to concentration camps. Concentration camps were just that. Groups of people concentrated together to get them out of society. Jehovah's Witnesses was one of the first of them. Before the Jews were pointed out and ultimately ended up being the foremost groups in concentration camps, which then became extermination camps, the Holocaust. So there was a dictate by the chief of the Jehovah's Witness in Germany, which said to everybody in the international realm that they will not worship graven images. So when various states would pass laws mandating that before class would begin, everybody would stand and salute the flag, the Pledge of Allegiance. They would stand and just not pledge allegiance, not defiantly, just would be very quiet and do that. Well, they got thrown out of school. Next thing you know, the question arose before the United States Supreme Court as to whether that was constitutional for states to create and mandate that people would pledge allegiance to the flag. Just a little note, the Pledge of Allegiance at that time was, I pledge allegiance to the flag of the United States of America with palms up. That's how it looked. Looks pretty close to that. So that was not permitted within their religious realms. So it found itself in 1940 in a case in Pennsylvania, and the case ruled that, in fact, it was deemed constitutional. States could, in fact, enact a law which would require the standing and the recitation of the Pledge of Allegiance. And if you didn't, you could be thrown out, which is what happened, which resulted in a tremendous persecution of Jehovah's Witnesses in the early 40s. Similar case came up in 1943. In 1943 in West Virginia versus Barnett. You'll hear that today. You'll hear that case today. What's different? Jackson joined the court. What's different? The decision was different. It became and was ruled unconstitutional to require and mandate the salute to the flag in a schoolroom setting. As a result of how Jackson phrased the opinion, how Jackson has been quoted over and over and over again today, very much well quoted, and you'll hear that today. You'll have to stay tuned and listen to that. And as a result, this becomes part of the conversation with the NFL, part of the conversation with Colin Kaepernick, conversation with the kneeling, conversation with Nike, all those things you've seen today. This will all be the topic of conversation that you'll hear not only from the Buffalo News reporter, but also from Professor Drew. Jackson went on until he died in 1954. He died in 1954. There was a funeral in Jamestown, New York, where all the justices came. And during his lifespan, the other thing that he's most remembered for is probably being the chief American prosecutor at the Nuremberg trial. The Nuremberg trials in 1945-46 against all the top Nazi officials was, in fact, probably the biggest criminal trial in the history of criminal law. And Jackson, from here, who never went to college, never graduated from law school, a Western New York lawyer who became a justice of the Supreme Court, whose name is on the courthouse, was involved in that. So I just want to give you that little prelude. We're going to start in just a minute, but thank you for your attention and glad you came.
Oh yay, all rise. The United States District Court for the Western District of New York is now in session. The Honorable William M. Skretny presiding.
All right, it's not often that I get to see so many smiling, eager faces in this courtroom, but it truly is my pleasure this morning to welcome all of you from, among other places, I think, Buffalo Seminary, Hutchinson Central Technical High School, Buffalo Academy of Visual and Performing Arts, and Emerson School of Hospitality. I think Judge Fascio is an alum of Hutch Tech, so that's why he was, yeah. And I'm, we're here on this very fine, wet morning, and we're all here gathered at the Robert H. Jackson United States Courthouse. My name, as you heard, is William Skretny, and I'm a trial judge here in what is the Western District of New York, and we are one of 94 federal districts in the United States. And I was appointed to the federal bench just a couple of years ago, back in 1990, by President George Herbert Walker Bush. A lot of names, but that's only one man. And if you know the presidential sequence of numbers, he is Bush 41, his son was Bush 43. And today is a special day for us. Today, we federal judges, and we're assembled here, and I'm going to introduce them to you in just short order, have the honor of hosting you and the American Board of Trial Advocates, or you'll sometimes hear it referred to as a BOTA, as they present and we present the 6th annual James Otis Lecture to commemorate and recognize Constitution Day here in the United States and in Western New York. In the gentlemen in their robes in front of me, I'm going to introduce to you, you've already met Judge Fascio, so I'm not going to repeat his introduction, but we have Judge, no, once is enough. Judge Romer is the gentleman that just raised his hand. Judge McCarthy is tied up for just a short period of time in his courtroom with proceedings this morning. He will take his place in short order. And I saved kind of the best for the last. Judge Scott, you're going to hear from him and his presentation in just a little bit. You know, you probably know this already, and no, I was not there, and the judges that you see in front of us were not there. And this was back in September 17th of 1787. It was at that time that the founders of our great nation, 39 state delegates, voted to approve the draft of the United States Constitution. And so today is a great celebration of that event and our Constitution. And you may know this, but there are 4,543 words in our Constitution, and they are inscribed on the glass entrance pavilion wall of the curtain wall of this particular building, the courthouse. It's the only courthouse in the country that has inscribed in it, etched in it, the United States Constitution. Our Constitution is a historic document. I don't need to tell you that. I know you know that. But it is the product of a hard-fought compromise and a number of compromises that were reached over the course of several summer months of debates in Philadelphia. It is also a changeable document. There are, after all, 27 amendments, and it is those compromises that give this document its persevering power. So on this day, almost 240 years ago, after the signing, we celebrated with today's program entitled Freedom of Expression, Just Do It. Our focus will be the First Amendment, which states, and I quote, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble, and to petition the government for a redress of grievance," close quote. Specifically, we celebrate and consider today the guarantees and the limits of the right to protest, and we do it in a building named after Justice Robert H. Jackson, who was an Associate Justice of the United States Supreme Court, who spent most of his life waiting for Judge McCarthy to come in. And it was Associate Supreme Court Justice Robert Jackson who once wrote of the majestic generalities of the Bill of Rights. That's pretty fancy, right? But today, we're going to consider our Constitution and the First Amendment on a more familiar personal level for us all, I think: social protest during sporting events by professional athletes. Most specifically, you're going to hear about Colin Kaepernick's refusal to stand during the playing of the national anthem at NFL football games. This topic of symbolic protest happens to be quite a personal one for me. 1969 was the year I graduated from Howard University Law School. I happened to be, back then, one of a handful of white law school students on a predominantly black university campus at that time. At my graduation ceremony at Howard University in 1969, Shirley Chisholm was the keynote speaker. Some of you may recall, and I think Shirley was actually a friend of Judge Scott's, that she hailed from Western New York. She came from this area and represented the 12th Congressional District in the United States Congress. Congresswoman Chisholm served for 7 terms from 1969 to 1983. And as an interesting aside, she became the first black woman elected to Congress and the first to be a candidate for a major party's nomination for President of the United States. The timing of my graduation, interestingly, was significant. It took place on the heels of the Black Power salute, which for the first time was made from the podium during the 1968 Olympics by medalists Tommie Smith and John Carlos. Congresswoman Chisholm, at my graduation ceremony, called for the entire assemblage at campus of students, faculty, and families to stand, raise their right arm and fist, bow their heads, and give the Black Power salute. For me and my family that were in attendance at that time, and my mom was there, my dad, my sister, this was a watershed moment. The symbolism was powerful. It was the exercise of the right of legitimate expression, with then the intended purpose to be an effective engine for change. Moreover, it did not put others in danger, and it did honor to the memory of the assassination of Dr. Martin Luther King Jr. In 1968, and as you know, Dr. King stood for nonviolent expression when fundamental constitutional rights were at issue. To me, this poignant moment at my graduation ceremony had a real and lasting impact. What I witnessed back then was the application of constitutional principles that were real, that were living, that were meaningful. They just were not abstract. That was life at the time. So today, you are going to hear about the case of, among others, West Virginia's State Board of Education versus Barnett, decided by the United States Supreme Court in 1943. So it's 75-year anniversary today of that very historic decision. The majority opinion in that case was written by Robert H. Jackson, for whom our United States Courthouse is named. And just so you know, he is in everybody's circles, either the top or at least in the top 3 writers in terms of the quality and character and of the writings that he participated in at the United States Supreme Court, which says a world about Justice Jackson and the fact that he is from Jamestown in Western New York. That case, the Barnett case, expressly overturned a prior Supreme Court decision. It pertains to compulsory flag saluting in schools and involves students who are Jehovah's Witnesses. So I urge you to hold on to your seats because this is going to be one heck of a program this morning. I know that a lot of hard work made today possible, including the efforts of your teachers, the administration at your schools, and our own court and technical staff, Mary Labazetta included. Hard work also from today's speakers, and you're going to be hearing from them shortly, whose decision I am certain will prove, and whose discussions will prove insightful and enlightening today. We're also going to hear from Hugh Russ, III, President of Buffalo Chapter of ABOTA, attorney and ABOTA's own Michael Perley, and you've probably had him lecturing at your schools, but without his efforts, none of us would be here today. Jay Skurski, whom you might watch at 10 o'clock every Sunday morning in the discussions of the Buffalo Bills and sports here in Western New York. He's a Buffalo News sports reporter and the Buffalo Bills beat reporter. I mentioned Judge Scott because he wanted to be mentioned at least twice today. He's going to tell you a little bit about federal jurisdiction and the trickle down from the United States Supreme Court to where you are right now. Greg Peterson, whom I think you've already probably heard enough of and from, and he's co-founder of the Justice Jackson Center in Jamestown, New York, and Professor Helen A. Nellie Drew, Professor Drew. She's the sports law expert from the State University of New York at Buffalo Law School. Now, we also have here, and I'm thrilled and I'm very appreciative and very thankful to have my judicial brethren, my judicial colleagues, my very esteemed judges from the New York State system in the jury box here this morning. Judge Erin Perodato, good morning. She's from the Appellate Division, 4th Department, essentially in Rochester. The Honorable John Curran, Appellate Division, 4th Department as well. Supreme Court Justice Donna Sywick, and she's in New York State Supreme Court, and also from the New York State Supreme Court, the Honorable E. Jeanette Ogden. She wanted to have a few more names and a few more initials, but we wouldn't let her put them in the program this morning. But what's going to be special about all of them is they're going to be joining us for lunch afterwards. And please be free to discuss today's program, what is of interest to you in terms of the Constitution. They'll answer questions, they'll lead discussions. Did I miss somebody? Judge Johnson. Oh, and Honorable Barbara Johnson-Lee. All right, you know, she kind of gets lost when she sits next to Judge Ogden. Yeah, I mean, it's just the way it is in our system. But I'm sorry, and so to give you some accolades, you were the first one to arrive here this morning. That's how excited that Judge Barbara Johnson-Lee from Buffalo City Court was this morning, and we go back a long way. I mean, there couldn't be anybody nicer than Judge Lee. So if you're going to appear in her court or in city court, ask to be in her courtroom. That's a good place to be. And again, they're going to be joining us for lunch to answer questions, to have discussions. So a lot of weight to you this morning. I'm not going to take up any more of your time. I eagerly invite Hugh Russ to the podium, please, to get our program started. I know. Judge Lee, I'm sorry.
Good morning, everyone. I'm Hugh Russ. I am the president of the local chapter of ABOTA, the American Board of Trial Advocates. And before I say my few words about ABOTA, I got to say I'm usually on your side of this. It's really weird being up here. So I think I'd rather be where you are, but I'll do my best. On behalf of the American Board of Trial Advocates, Buffalo chapter, I want to welcome all of you to our 6th annual James Otis Lecture. Founded in 1958 by attorneys to preserve the right guaranteed by the 7th Amendment of the Constitution, the right to a civil jury trial, ABOTA is devoted to making trials not only possible for everyone, but accessible to everyone. ABOTA also seeks to preserve the independence of judges. I know some of you are probably watching the confirmation proceedings that are happening right now, and obviously there are issues involved there. Finally, ABOTA and the ABOTA Foundation provide education for students like you. In particular, we have a program called Justice for All, which is an interactive DVD available for middle school students, so a little younger than you, but that's one thing we do. The other thing we do is this James Otis Lecture. Now, you may wonder, who was James Otis? James Otis was a lawyer in the 18th century, that's the 1700s, who argued for the rights of the colonists and for the limitations on the power of the government in a case that's known as the Writs of Assistance case. That was in 1761. This lecture today and this lecture series honors his memory as one of the lesser-known architects of our constitutional system. And even though he is not as well known as some of the more famous people you have learned about in school, his contributions to our Constitution were critical, and they persist even until today, as you will be hearing shortly. So thank you all for coming. I welcome you, and I look forward to a fascinating morning.
All right, the gentleman that you heard referred to as the practicing lawyer in Western New York, without whose dedication and commitment to the James Otis Lecture and this program and our gathering, and we wouldn't be here today without Michael Perley. Michael.
Good morning, all of you. I think I saw most of you in the lobby downstairs, but I also want to welcome you officially to our 6th annual James Otis Lecture. When we were looking at the program that we wanted to present to you today, and we decided upon the idea of investigating the constitutional limitations and implications of the professional athletes' protests, we needed an individual who could help us understand the way professional athletes think and what motivates them. And we came upon the perfect choice when we were able to invite Jay Skurski, and he accepted our invitation to speak to you this morning. Mr. Skurski is a well-regarded and award-winning newsprint reporter. His ability to communicate with professional athletes, both on the Buffalo Bills and our hometown teams and others when he's on the road, and his representation of them as a fair and honest reporter allows him to provide you today with insights into the way that they think. It is my distinct pleasure to introduce Jay Skurski.
Hello, everybody. Good morning. Thank you very much for inviting me to speak and for being here today. What I would like to do is to try to give you some of the background. Some of you may be familiar with the protests that have taken place during the national anthem, started by Colin Kaepernick a couple of years ago. But for those of you who maybe aren't, I think it's important that I give you some of the background in terms of why it is that Colin Kaepernick started to do what he did. So, Colin Kaepernick has become larger than football since he refused to stand 2 years ago as the national anthem played before NFL games. An icon in the fight against police brutality and racial injustice, Kaepernick has not played in the league since the 2016 season. Most recently, he was made the face of a new Nike ad campaign, which I'm sure many of you have seen. The commercial, which is filmed in black and white, ends with a close-up of his face and the caption, "Believe in something, even if it means sacrificing everything." In many ways, that's what Colin Kaepernick has done. His NFL career, as of now, is over, and many people believe that it's because of the protests that he started back in August of 2016, first by sitting and then later by kneeling for the national anthem before NFL games. This was Kaepernick's quote when he first was asked about why he decided to sit. "I am not going to stand up to show pride in a flag for a country that oppresses black people and people of color. To me, this is bigger than football, and it would be selfish on my part to look the other way. There are bodies in the street and people getting paid leave and getting away with murder. To me, something has to change. And when there's significant change and I feel like that flag represents what it's supposed to represent, and this country is representing people the way it's supposed to, I'll stand." Kaepernick first sat for the national anthem. He later started to kneel after he had a conversation with former NFL player and Green Beret Nate Boyer, who has become a mentor of sorts to Colin. His protest inspired other athletes, both in the NFL and in other sports, his teammate Eric Reed notably among them. After Kaepernick sat for the first time, his team and the NFL released statements saying players were encouraged but not required to stand for the anthem, which is played before every professional sporting event in the country. I'm sure if you guys have been to Bills or Sabres games, you are aware of that. In September of 2017, President Donald Trump said that NFL owners should respond to players who kneel during the national anthem by saying, and I quote, "Get that son of a bitch off the field right now. He's fired. He's fired." That, as you may well imagine, did not sit well across the NFL. In an act of defiance against Trump's statement, players from 28 teams participated just days later, almost exactly a year ago to the day, in some form of protest. That included coaches and team owners. The Buffalo Bills had 12 players who elected to take a knee during the national anthem before their game against the Denver Broncos. Lorenzo Alexander, one of their team captains and a representative for the National Football League Players Association, spoke after the game about why it is that he decided to be among those 12 who took a knee. And I quote, "It was in response to our president's comments calling people who were peacefully protesting SOBs. For me, with the background being Charlottesville and calling neo-Nazis and KKK members fine people, making that comparison and drawing a hard line versus NFL players who were doing something peaceful really touched me. The night before the game against the Broncos, the Bills had a voluntary team meeting that involved their team owners, Terry and Kim Pagula, their coach, Sean McDermott, and their general manager, Brandon Beane. It was termed an open dialogue, and it was an hour-long conversation held in the team hotel that turned emotional at several points, as you could imagine. More from Alexander. For the guys who are taking a knee and trying to bring awareness to social injustice and inequalities in this country, it doesn't mean they're not patriots. It doesn't mean they don't love their country, because we do. We have great privileges here. But being a U.S. citizen, I also want to bring attention to things that need change. I'm with our military and with our country, but I don't think you can put us all in a box and draw a line and say, I have to be with my country or with social justice. Hey, I can be for everything, and that's the point we wanted to get across. After coming out of the tunnel together as a team, the Bills gathered on the field and locked arms and walked onto the sideline. That was a change from the way they had approached the anthem before. Some of the other players who took a knee included Ryan Davis, Mike Tolbert, Jordan Matthews, Sharice Wright, Leonard Johnson, Cedric Thornton, Shaq Lawson, Marcel Darius, Tywan Jones, and Kalen Clay. We just felt like it was the right thing to do, Sean McDermott, the coach, said of walking onto the field. McDermott otherwise kept the details of that Saturday night meeting private, but in speaking with the Bills, and actually the Broncos on that day, they further explained why they decided to do what they did. Me and my teammates, we felt like President Trump's speech was an assault on our most cherished right, freedom of speech, Broncos linebacker Von Miller said. Collectively, we felt like we had to do something for this game. We couldn't just let things go. I have a huge amount of respect for the military, our protective services, and everything. I've been to Afghanistan. I've met real-life superheroes. It wasn't any disrespect to them. It was for our brothers that have been attacked for things that they do. I felt like I had to join them. As you can imagine, the reaction inside New Era Field that day was mixed. There was audible booing from some people in the stands. You can't please everybody, Alexander said of the pushback to the protest. You can explain where you're at, and they're going to hear you or they're not going to hear you. We have some guys on this team that won't kneel, but it's all about respecting people's opinions and perspective. We still love each other. That's what this country is all about. Colin Kaepernick, for his part, has been honored by several different organizations, including GQ, which gave him the Citizen of the Year award in 2017, and Sports Illustrated awarded him with the Muhammad Ali Legacy Award. He's also received the Eastern Moreau Courageous Advocate Award from the American Civil Liberties Union of Southern California. Things changed in 2017 for Kaepernick when he became a free agent. He ended the 2016 season on injured reserve, and although his performance had declined somewhat, most around the NFL believe that he's still good enough to play in the league. However, he has not been signed to this date, which led to him filing a grievance against the league, claiming that he's being colluded against by owners because of his protesting. Athletes who peacefully protest should not be punished, Kaepernick's attorney said in a statement. Still, players continued to kneel, and public backlash mounted until team owners in May declared that all team personnel on the field during the anthem must stand and show respect for the flag and the anthem. Now, that happened in May. It was in July, however, that the NFL dialed back that policy, and it basically rescinded it. So the league said that everyone on the field had to stand and show respect for the flag and the anthem. Teams would be fined by the NFL for violation. In an August statement, the league said that is still the policy, but players and teams won't be disciplined for violations. So in other words, the NFL is now back in the exact same place it's been since Kaepernick first started his protest. Quite frankly, this has been an embarrassment for the league in many ways. What does it mean for players? Well, they are free to continue to express themselves as they see fit. Now, I should mention that, at least in regards to the Buffalo Bills, after that initial game where a dozen players took a knee in protest, the following week, 6 players continued to do so, and by the week after that, none of the players have done so. And that has been the case since then. All of the Bills have stood for the national anthem. What NFL owners did today was thwart the players' constitutional rights to express themselves and use our platform to draw attention to social injustices like racial inequality in our country, said Eagles safety Malcolm Jenkins, who has become, along with Kaepernick, a leading voice in this movement. The removal of the policy is a win for those players who want to continue to have their voices heard without threat of punishment. On the week following the Bills game against the Broncos, I had the opportunity to speak with all 12 of the Bills who decided to take a knee for that game. I wrote an article in my Sunday column that was called "Why I Knelt. 12 Players Explain Their Decision." And my thinking was that I wanted each of those players to say as much or as little about why it is that they decided they wanted to take a knee. I think it's important that I share a couple of those opinions with you. Ryan Davis said, "It was important to me because I've always felt when Kaepernick came out understanding why he took a knee, I thought that was very commendable. I agree with him from the very beginning. When the president made those remarks, it was almost like conviction. I took it personal. I was really talking to myself, like I really need to show my family, my friends, my community, everybody back home looking at me, who I am and what I represent." Mike Tolbert, "For me, as a black man in this country, I've seen firsthand why Colin Kaepernick started it. Being pulled over for no reason, sitting on the curb with my hands in handcuffs for no reason. Stuff like that. And also, I've got kids. You know what I mean? I've got kids, man. I've got a son that's going to be a black man at this country at one point, and I don't want him to have to go through that." So, as you can hear in these comments from players, this is a deeply personal issue for them, and they have all been affected by it. To a man, I have not heard one single player express any sort of issue with what Colin Kaepernick has done. Now, that's not to say that privately or personally they all agree with it, but the NFL as a whole is united in supporting Colin Kaepernick. Where his collusion trial goes will be one of the fascinating things to follow in the league this season. It is surprising to me that he has not received another opportunity in the NFL. I could think of one team here in Buffalo that maybe could use a quarterback. Interestingly enough, Eric Reed, who was his former teammate with San Francisco, just signed with the Carolina Panthers within the last couple of weeks. What does that mean for Kaepernick moving forward? What will Eric Reed do when he is on the field? Will he continue to protest? That remains to be seen, but I think it was interesting nonetheless that for a player who had sued the league for collusion, he was no longer being colluded against because he's been signed. So, you know, that's good for Eric Reed, but honestly, Colin Kaepernick, and, you know, again, I'll go back to the Nike ad, has become the face of this movement. And, you know, I think every person in the NFL has a different opinion on it. And right now, the league is struggling mightily to come up with a uniform understanding or policy of how they want to handle these things going forward. So I think that is some of the background regarding these, you know, this protest that was started by Kaepernick, and I hope that gives you guys some further knowledge exactly of where players in the league stand and maybe why Colin Kaepernick did what he did. So thank you very much.
Thank you very much, Jay. That was very insightful, and of course, Jay has a lot of firsthand experience in the sports world. You know, and it does highlight for us today's topic, which is freedom of expression. Just do it. And, you know, that's the beauty of our Constitution. We don't have to agree with every person who says something. We don't have to agree with what is being said. Our Constitution protects all of that. It protects the person who speaks. It protects the person's beliefs. It protects us who hear what we hear and what we want to hear. Our Constitution makes our country great. And what makes it greater and stronger is the ability that we have to dialogue, to keep our minds open, to explore every aspect of what is being told to us. It does require thought. It requires to look into the facts and the circumstances and to make sure that we become informed. And that's the beauty of our private and public school systems, because you're taught to learn, you're taught to explore, you're taught to investigate, you're taught to think. And that's what our Constitution wants to guarantee. Your rights to do that, your right to speak, your right to protest, your right to take in what is a part of everyday life, not only in the sports world, but in every single thing that we do at school, at work, at home. That's the beauty of our Constitution of this great country. Okay, with that, Judge Scott, you know, we set you up. I mean, it's like a cream puff for you. All right, he's going to tell us a little bit about the court process and how that all comes into play when we're talking about the federal Constitution, the state Constitution, and judges who are part of the system.
Thank you very much. I'd like to echo everything Judge Skretny said about our country and our Constitution. And I want to really thank Mr. Skurski. That was very informative. And I think these young people, this is a real opportunity for them to hear an analysis that makes sense about this whole issue. So thank you very much. I also want to make sure that you remember earlier this week when Mr. Perley spoke at your schools in preparation for this program. During his presentation, he discussed the United States Supreme Court and the impact that cases had on the rights of protesters. Quite often you hear from lawyers and laymen, you know, the federal court is complicated and it's paper and it's burdensome. I don't think so. And I think this is a place where you can come, have your disputes resolved, and I think we do a real service. And that Constitution that we're talking about makes this country really, in my opinion, and I guess everyone else, one of the greatest countries in the world. So I just want to say that. So the structure is somewhat, it's interesting. It can seem a little complicated, but let me see if I can make it understandable. Now, the Supreme Court is the most important court in the land. But district courts like this one are where much of the action happens in this country. We are the trial courts of a three-level federal court system. And in fact, the drafters of the Constitution themselves gave Congress the power to create these courts. Article 3 of the Constitution states that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. They probably could have picked a better word than inferior, but that only refers to, just really only refers to superior, inferior in terms of what's below and what's above. Of course, I know Judge Skretny could have had some input in that language over 200 years ago, but that's all right.
But I didn't have my thesaurus with me at the time, that's Judge Scott.
He could have done very well doing that. So the Western District, that's where you are right now. This court is one where cases are heard, just like the case you heard about from Mr. Perley, and that's the West Virginia State Board of Education versus Barnette. So like all district courts, the Western District of New York is made up of district judges like Judge Skretny and magistrate judges like myself. Federal district judges are nominated and appointed for life by the President of the United States, subject to confirmation by the Senate. And that's what you're watching on television right now, taking place. This way, and this process is such that it prevents people from being removed from the bench because they decide a case in a way that some people may disagree with it. And magistrate judges such as myself are appointed, and we're often said to be on the front lines of litigation. We oversee pretrial proceedings in both criminal and civil matters. We issue decisions and reports and recommendations that shape the scope of a case and sometimes resolve a dispute from the start to finish. Now, district courts are abuzz with activity. Every day people are arrested and they're brought here to this court for arraignment. Hearings and trials, important civil matters are also addressed here. A civil case simply means that it's not a criminal case. And I like the explanation that a civil case is usually a dispute over money and property versus a criminal case where something is done that affects adversely the citizens of this country. So, now, as I said, I don't think district courts are inferior, but despite best efforts, I also know that they are not infallible. Congress knew this too, and so it developed an appellate system to which litigants who believe the district court erred can appeal. And like the district courts, which represent geographic portions of the country, appellate courts are split into circuits. And each of these circuits hear appeals from certain designated locations in the country. And in our part of the country, appeals are heard by the Second Circuit Court of Appeals. And that is the court that heard the appeal in the Barnett case that Mr. Perley talked about. In fact, the Second Circuit hears cases from all over New York, Connecticut, and Vermont. And just so you also get a sense of it, there are 13 courts of appeals in the United States, covering different regions of the United States. So that's kind of the that's an easy way to follow it. You have district court, appellate courts. There's 13 of them, and then the Supreme Court. We are one of 94 district courts. We are 94 districts in the country. I don't know if you've studied that yet, but that's the way it is structured. Now, decisions from these 13 courts of appeals can be challenged in our highest court, and that's, of course, the United States Supreme Court, located in Washington. And cases that have reached the Supreme Court from a state court, there are some that do, and that's when, if a decision of the state's highest court is challenged, then that challenge may be heard by the Supreme Court of the United States. The Supreme Court consists of 9 justices who hear cases from all over the country. Majority rules in this court. 5 votes is all that's required to dispose of a case. I'll let your teachers quiz you later on whether the Constitution requires that there be 9 members of the court on the court. And I'll give you a hint that if it doesn't, we're in trouble, as we only have 8 right now. So that's how cases reach the Supreme Court, either through a 3-part federal system of district, circuit, and appellate courts, and then the Supreme Court, or through an appeal from the highest state court to the Supreme Court. So that's as simple as I can make it. It's not really that complicated once you work in it every day, but I thank you for your time. I wish they'd had these programs when I was coming through school. By the way, I went to Touch Tech for 2 years. All right. Okay.
Did you graduate from any place, or?
No, I didn't. Now go back and check. That's right. Extend the FBI check. So I look forward to talking to you at lunch, and we'll have a very nice discussion. Mr. Perley, again, thank you for your efforts in putting this program together every year. We look forward to it. Thank you.
Thank you, Judge Scott. You know, if you get a minute or two to speak with Judge Scott at lunch, Judge Scott has made an invaluable contribution to our court. Part of his legacy is what's called the Reentry Program. And it is actually absolutely an emotional and amazing court. It actually works with integrating convicted felons, the highest level of criminals, upon their release, and it works to integrate them into our everyday society. It's an invaluable transitional court. Judge Scott has put a lot of time and effort into that, and the results in making individuals actually able to participate in everyday life a reality. So, Judge Scott, talk with them about that. It's just an amazing experience, and thank you for your efforts in that regard. Okay, the co-founder of the Jackson Center in Jamestown and practicing lawyer here in Western New York, Greg Peterson.
Thank you, Your Honor. It's a delight to introduce our principal speaker today. The stage has been set. We've discussed the Colin Kaepernick case, and we've discussed a little bit about West Virginia versus Barnett. We've also discussed about the fact of the question of infallibility, which brings to mind Justice Robert Jackson in a case. And he said about the United States Supreme Court, because as Judge Scott said, there's the District Court, there's the Circuit Court of Appeals, and then there's the Supreme Court, which is the final. And he said, Justice Jackson said, we at the Supreme Court are not final because we are infallible, but we are infallible only because we are final. So hence, there is no greater than the Supreme Court. Thrilled today to introduce Professor Helen Nellie Drew. She has a resume a mile long, and it's like many, many pages. But suffice it to say, she's a professor of practice in sports law and the director of the SUNY Buffalo Center for the Advancement of Sport, a cross-disciplinary initiative that fosters academic research, policy development, and programming in the sports industry. She's a graduate of the University of Buffalo Law School, having received her undergraduate degree at Harvard. And she also completed an honors senior thesis under the direction of former U.S. Solicitor General and Watergate Special Prosecutor Archibald Cox. I want to talk more about that. That's fascinating. She was also in-house counsel to our professional hockey team, the Buffalo Sabres. And there she was involved in contract matters, including dealing with Pat LaFontaine, you remember that, and Dominic Hasek. But of most interest to me, as we just had a program in the Robert Jackson Center dealing with one of the Buffalo Sabres hockey stars who was the first to be defect from Russia, dealing with Alexander Mogilny. We had Don Luce down there just recently, before that Jerry Meehan, and your name came up a lot. Her academic interests range from concussion and player wellness issues to Title IX and domestic violence in sports. She will be talking on the title, Freedom of Expression, Just Do It. And before I ask her to come forward, the story about the Barnett case, which many of you heard about earlier today before the event, is real. It came in just yesterday, where the headlines was, Texas Attorney General takes on black teenager expelled for sitting during the Pledge of Allegiance. Texas Attorney General Ken Paxton threw his weight behind a school defending itself against a lawsuit brought by a black teenager expelled for refusing to stand during the Pledge of Allegiance. The student argues her expulsion is a violation of her constitutional rights. So when you think Barnett, 1943, sort of settled the issue, it's in play here in Texas today. Ladies and gentlemen, Professor Helen Nellie Drew.
Good morning. Thank you for being here. I appreciate the invitation very much. Hugh, Russ, an old friend. I was saying to him earlier, I think we were in our first sports law class together. It was a long time ago. We had an argument then about whether girls and guys should play ice hockey together, and neither one of us budged. So he's still a very good advocate. Also to Mr. Michael Perley for the effort he made to organize this program and for BOTA. It was interesting to hear Judge Scott mentioned how nice it is to have this program. I know it's been a long morning for you, but I will echo that. When I was in your shoes, I was first generation to attend college in my family. I didn't know any lawyers. I had a very vague notion I wanted to be a lawyer, and I didn't have this type of experience. So it's mentioned in my biography, I went to Harvard College, and my very first class as an undergraduate, was in Langdale North Middle, which is the big lecture hall at Harvard Law School. And my first professor was Archibald Cox. And I sat down there in the front row, and I was like, wow. And I was sold. And I haven't looked back. And it's a really great thing to get up in the morning and love what you do and want to do it. And I hope that this, I can't aspire to be Archibald Cox as he was to me that day, but I hope that this program will give you some insight, and perhaps if you're interested in a career in law, I think that the members of the bar would agree with me that there has never been a time when we need more bright, capable, energetic, passionate young people to consider a career in law, so I hope you'll consider doing so. So the title of the talk is, freedom of expression, just do it, right? So how many people here are sports fans? Awesome. So did you see that leap that Josh Allen made? Yeah, was that great? Too bad he couldn't repeat it against the Packers, huh? Next weekend. I'm not sure we need another quarterback right now. I'm good with this guy. He's got a lot of energy. How many people here think they might be interested in being attorneys? Okay. Well, maybe we'll encourage a few more of you. Okay. Mary? Okay, so as mentioned, this is we're in the Robert Jackson Courthouse. If you see a picture up here on the screen, and he's from Jamestown. And I encourage you, if you have the time, to take a little bit of effort and get on your phone and look him up once we get out of the courthouse and read about his life. A very interesting man, very well written. Thank you. And what do he and Colin Kaepernick have in common? Well, take a look again at the screen, and you'll see the First Amendment. Both very, very strongly interested in that. Okay, I can't see it very well myself here. So I was told I can't walk. Sorry, I'm a professor. I walk and talk. Oh, very good. Thank you. So 1940, there's a case. You see it there on your screen.
You can move it over here if you want. That's better.
Minersville School District versus Bidas. What's happening? Anybody here take AP US or AP Euro? Oh, yeah. Great class, huh? Yeah? Wait till you get there. You'll be glad you took it in the end. What's going on in the world in 1940? Okay, so kind of in context, just much like Colin Kaepernick, things are going on in the world. What do you suppose people in the U.S. are thinking as events are transpiring overseas in Europe? Worried about getting into war, right? So this surge of nationalism, and there's this law passed that everybody should stand and say the Pledge of Allegiance and salute the flag in school. A lot of schools do that now, right? Okay, so this case comes up before the Supreme Court. The Supreme Court's like, that's a good idea. That's a good idea. We want to inculcate values of patriotism and loyalty. That's okay. Mary, just go forward. And what's the problem? Well, there are some people, and you've heard about them this morning already, Jehovah's Witnesses, who have a very literal interpretation of portions of the Bible, including that right there, which I can't read verbatim from here. My eyes aren't that good. But essentially the essence of it is that they are required by their religious beliefs not to worship or to pledge allegiance to what's considered to be a symbol or a graven image, and to them that's the flag. So they have a really big problem with sending their kids to school to salute the flag. And so parents of Jehovah's Witnesses children were sending their kids to private schools and paying the freight for that rather than sending them to public schools. And that was a problem, and it didn't go away, much as we hear these issues keep recurring, right? The First Amendment is as vivid now as it was back when it was first enacted. And the case comes before the Supreme Court again 3 years later. So you AP US people, what was going on in 1943? Where's the US then? Middle World War II. Can you imagine what it's like then in World War II, right? People are very, very worried. Families are sending their sons overseas to fight. They've lost sons. This is a very, very hot topic, okay? And it comes up before the Supreme Court again. And again, I apologize, I can't read the quote from here. Essentially, Justice Jackson, who is incredibly well written, writes for the majority. And I just pulled out one quote that struck me the entire opinion is well worth reading, and it's written in English. It's very, very well written. It's a document that you can understand. I know when I first started law school, I would read cases. Some of those in contracts are pretty bad, right, Hugh? And you, old language, old English made not a whole lot of sense, but that wasn't Justice Jackson. He wrote very, very easily understood prose. And what he said was, but freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to things that touch the heart of the existing order. So what does that mean? What do you think that means? What kinds of issues is he talking about there? Anybody talk? You can speak. I know it's Gordon. You can talk. Anyone guess? What's he talking about there? Sure. Yeah.
Is he talking about how freedom is equally protesting things that matter a lot versus protesting things that only matter a little bit? And in this case, protesting the saying of
Yeah, exactly. I mean, if everybody agrees with you, you don't need to worry about freedom of expression, right? Because nobody's going to be telling you, shut up. It's that simple. Here. So one of my favorite justices is Justice Oliver Wendell Holmes. He got a baseball case wrong, but we're not going to talk about that right now. Only thing he ever wrote badly, and it was well written, but it was the wrong result. In any event, he said something similar. He said, if there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom for the thought that we hate. What does that mean? The thought that we hate. Yeah. Yeah, and the really poignant part of the case that Justice Jackson wrote to me was the fact that it had to do with public education, right? So in that case, in the Barnett case, the situation involved something similar to the previous case, but the students are being kept home from school. The parents couldn't afford to pay for the private schools. The kids are being kept home from schools, which means they run the risk of what? Failing? Yep, chance of being successful? Truancy, and parents were even threatened with being imprisoned for not sending their kids to school. So this is a big deal. And again, reflecting back to what we heard earlier this morning, the very heart of public education, right? The ability to exchange ideas, freedom of thought, okay? So are there any limits to freedom of expression? Yes, like what? Give insights. Terror or violence? Anybody else? Chaplain? Yeah.
if you're sitting in a facility, you can't really get on fire.
Fire in a crowded theater. See the flames there? That's not just my high school's mascot. Yep. Okay. Okay. So to some extent, so typically three. Okay. The kaboom means you can't have fighting words. Fighting words. Words that are calculated to incite violence. Flames. The idea of fire in a crowded theater. The final one is obscenities. You're not supposed to do that either, right? Okay. The rest depends upon where. So does the First Amendment apply everywhere? Go to Wegmans, you see those signs that say you can't solicit or whatever, or right? Okay, why? Why do they have those signs there? It's a business, okay? Is it public or private? It's kind of a mishmash, right? So why did I pick City Hall? What's City Hall? Public, right? So does the First Amendment apply to City Hall? I'm questioning the justice here. I presume it does, right? So it applies to state action, right? It applies to state action. So Niagara Square, we've seen protests in Niagara Square, right? So within the bounds that we've already described, that's fine. Right? How about schools? Anybody see a school up there? No. Ooh, I heard a no. Where was the no? Okay, what's the no? Okay, so in public school, it's an odd mix. You can, and you do have the right to First Amendment freedom of expression within certain parameters. There's a big case, and again, this is a 1969. What was going on in 1969? Have you hit that yet, DPUS? What was going on in 1969? Dr. Skretny referred to it. You were graduating.
1969. Yeah.
Anybody know what this case is about?
It's about peaceful America in the Vietnam War who wore a black man on their shoulders and they were suspended from school.
Right, so were they saying anything? No, and that was a large part of this case. These students went to school, and they were wearing black armbands to protest involvement in the Vietnam War. They weren't saying anything, they weren't being unduly disruptive, they just were wearing black armbands, and that was, great offense was taken at that by the administration, so they were suspended. Case goes up to Supreme Court. And the court says it can hardly be argued that either students or teachers shed their constitutional right to freedom of speech or expression at the schoolhouse gate. So there you go. You do have First Amendment rights, at least in a public school setting, right? Unless you can't be disruptive. What does that mean? Sure. So now, did any of your schools do the march, walk out from school and protest? Okay. So our students in my children's high school did as well. What did you guys do? Stood outside. Anybody else? School administration was okay with it? Yeah? Okay, so my kids and I actually went down to Washington, D.C. and did the march. It was an amazing, amazing event. First really large political protest I've ever been involved in. It wasn't my idea, it was my kids. But when it came time for that event to leave school, our school administration said, look, we get it, we understand, we appreciate it, but we can't have you disrupting classes. So how about we do this? How about we escort you out and then limited period of time and we walk back in? And that falls within being non-disruptive, right? Can you just wholesale leave classes and slam doors and lockers? And no, that would be disruptive. But there, you see, there's a reasonable parameter there we're setting. Or if it's a private school. Sorry, guys, who here's at private school? Yeah, you buy in for the rules you buy in for, right? That's just the way the world works. How about employers? Anybody have a guess? How about an employer? So yeah, so it's kind of again, a mismatch of opportunity here. If it's a public employer, it's state action. And the current state of the law is that a public employee is free to speak about things that are matters that are not with respect to their specific job obligations. The idea being that's a sort of a different area, and that's somewhat contested. How about the NFL? Is the NFL an employer? Okay. How about, in this case, he was working for the San Francisco 49ers. Are they an employer? Public or private? Ah, therein lies the rub, right? Okay. So does the First Amendment apply? Anybody tell President Trump about the obscenity thing? Just asking. Sort of. I keep wanting to tell him to put the phone down. The players cannot be fined or imprisoned, okay, or punished by the government. Is that what's being threatened here? Well, kind of, but not really. I mean, President Trump is making a lot of noise, but is he in the process of doing that? No. How about the 49ers or whomever he might sign with?
They have the right to fire him or punish him for his actions.
Well, they certainly have the right. Right? There are some legal clauses in the collective bargaining agreement between the NFL and the NFLPA, as well as in the standard player agreement, that arguably would give the NFL and or a team that signed Colin Kaepernick the ability to discipline him. I put Papa John's on there. What happened with Papa John's? Yeah. That was sad. Why? What happened? Yep. And what happened to him? Pretty much got kicked out of his job, right? Was that okay? Doesn't that violate the First Amendment? Private employer, right? Okay. But what impact did that have on the NFL? This whole dispute, right? As Mr. Skurski mentioned, it's been a nightmare for the NFL. They did not willingly put themselves in this position. There are some other laws in addition to the CBA that might apply. CBA is private law between the NFL and the NFLPA. Title VI applies, potentially, as well as the Sherman Antitrust Act, which would be the basis for the collusion suit that Mr. Skurski mentioned. So far, we haven't seen that take off because the focus is all on the collusion case. And by the way, you'll see more about that coming forward, I'm sure. if it's legal, it's a good business. You guys all saw the Adidas ad. Did you see what happened? Nike. What happened afterwards? Excuse me, Nike, Adidas, Nike. What happened? Yeah, so initially what happened, do you remember? There was a small drop, like a 4% drop, and then it took off like a rocket. Who do you suppose they normally sell to? Who's their market? I'm looking at it, right? Okay, all right. So I'm sure they did some market research ahead of time, but it took off like a rocket. So pretty good idea, huh? Let's go back to Justice Jackson Barnett. What did he say? To believe that patriotism will not flourish if patriotic ceremonies are voluntarily and spontaneous instead of a compulsory routine is to make an unflattering estimate of the appeal of our institutions to free minds. We can have intellectual individualism and the rich cultural diversities that we owe to exceptional minds only at the price of occasional eccentricity and abnormal attitudes. What's that mean? What's that mean? What's he trying to say there? How many times do people get up, say the Pledge of Allegiance, have a sleep in the morning, right? What does that mean, right? What's he trying to say there? Yeah.
I mean, we can go along for days, but even if people are being involved in it.
Yeah, it's meaningless, right? That's the point he's trying to make. And you need to offer the opportunity for people to be, to be to be politely disrespectful, I guess, to take the knee, to do whatever it is appropriate. So the University of Buffalo is what kind of institution? Public institution. We've had these conversations with our athletic teams, and the athletic department is very supportive, and their response is, your students first. We want you to be engaged in academic discourse, and if you want to protest, we'll be there with you, but all we ask is that you be respectful of other people in the organization and in the environment as well. And just like, Mr. Skurski mentioned with the Bills team, the in-house conversation, what do you want? What are you looking to achieve? How can we get there? How can we be respectful of each other, even if we have different opinions? So what do you think? Just do it? And I think the big takeaway message here today is that you do have that freedom. You may suffer consequences, but you do have that freedom. And back so this is the law school. We pitched the law school. As I said, I hope this encourages you people to think about it. We have a very vibrant community here in Western New York. A lot of lawyers, a lot of alumni who came out of UB School of Law. And I'm happy to talk to you about careers that are open to you, both in sports law as well as in other opportunities. And the slide, I'll provide my contact information. And check out our sports law blog, ublawsportsforum.com. There'll be more in there about Colin Kaepernick, especially as the collusion case plays forward. I promise there'll be a post on that. And thank you very much. Hope you have a very great day.
Thank you very much, Professor Drew, and we really appreciate your being with us today. As you know, we, the court, are here every day to work towards doing justice, and I know I speak for my colleagues when I say that you most certainly did justice to the Constitution and the First Amendment and to discourse and discussion and chronology this morning. Some of your comments are certainly fundamental, but they're the comments from which we can build, and that's what's really important as we proceed through the educational ladder and through the things that we have to deal with every day. When you do get the opportunity, ladies and gentlemen, to speak with Professor Drew, I heard through my sources that she really was a force to be contended with when she was on the ice playing hockey in college. So you may want to ask her about that. I hope that you, Jay, invite Professor Drew to Sunday's program and discuss the quarterback situation with her. I don't want to tip my hand, but Professor Drew, I do agree with you. In any event, it's probably time for lunch, for answering maybe your observations and your questions this morning. I would like to end with just a few words that I think are particularly germane to today and the discussions that we've had, and I know that you will know that it's from the preamble of the Constitution, and in the words of that, we the people of the United States, in order to form a more perfect union, secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. And that's us. And we have an obligation. We have an obligation to build upon our Constitution, to make things right for ourselves and for others. And I hope you take seriously the comments and the thoughts and the inspiration that I think you probably have received this morning, just as we have. I mean, we're never too old to learn. We're never too young to contribute. So please, please, make this country better. That's your duty. That's your obligation. The Constitution is there to help you with that task. Thank you very much to the teachers, to all of you, to all of those that have participated, our judges and our speakers and our organizers and my staff. Enjoy lunch. Let's have a great discussion. Thank you very much.